Ito ang balita ngayon ay talagang magandang balita ito para kay dating Pangulong Duterte. Mga kaidol, mga kaibigan, mga kadidiis. Itong ah, Solicitor Guevara nagsalita na tungkol dito sa ICC. Panoorin natin ito. Sa hindi pa nakasubscribe sa aking channel, pakisubscribe at hindi pa nakapalo sa aking FB page, pakipalo. Ito, panoorin natin ito. Ang panayam ni Solicitor. Okay mga kaidol, mga kababayan natin dyan sa bansang Pilipinas, ito nga ay talagang good news ito para kay dating Pangulong Duterte. Ito, Solicitor Guevara, nagsalita na. Panoorin natin ito. Sa hindi pa naka-subscribe sa aking channel, pakisubscribe at pakipalo na rin sa aking FB page. Maraming salamat mga karameboy, mga ka-idol. Diyan sa ating bansang Pilipinas, ito ang mainit na balita ngayon.
We recognize the Honorable Menardo Guevara. Sir.
Good morning, Your Honors. I do not have any opening statement to make. I'm here to answer any questions that the members of the two committees may ask in connection with the ICC decision and on the issue of whether we have any legal duty to cooperate with the ICC prosecutor. First of all, Your Honors, I believe that the matter of whether we should cooperate with the ICC prosecutor is a political decision. And in that respect, the head of the Republic, the head of state, the President himself, has repeatedly declared that the Republic cannot extend its cooperation to the ICC in any form or manner whatsoever because national institutions are functioning which can actually do the investigation and prosecution here, and that any intervention by a foreign entity such as the ICC would be an encroachment on our sovereignty. So that is the political aspect with respect to this matter. But as Solicitor General and Counsel for the Republic, I am here to explain the legal basis on why there is no legal duty on the part of the Philippines to cooperate with the ICC. I will do so on the basis of a major distinction between the existence of jurisdiction and the exercise of that jurisdiction. Jurisdiction over the subject matter, Your Honors, is covered by Article 5 of the Rome Statute. That is jurisdiction over the subject matter, namely over crimes of genocide, crimes of aggression, crimes against humanity, and so forth and so on. Jurisdiction over the subject matter. And there is no doubt, as the Supreme Court pointed out, that the ICC has jurisdiction over offenses or crimes that happened during the time when the Philippines was still a member of the ICC. No question about that. However, the exercise of that jurisdiction is covered by a different section of the Rome Statute. Exercise of jurisdiction is covered by rules Articles 12 and 13 of the Rome Statute. And there are preconditions to the exercise of jurisdiction by the ICC. Most important of these preconditions for the exercise of jurisdiction is that the Philippines should still be a member of the ICC at the time that the exercise of that jurisdiction is triggered. All right, so when was the exercise of that jurisdiction triggered? It was triggered when the ICC prosecutor requested the ICC chamber, the pretrial chamber, to initiate or to commence an investigation. When did that happen? That request to commence an investigation, which should have triggered the exercise of the ICC's jurisdiction, happened in May of 2021. And the pretrial chamber granted that authorization to commence the investigation in September of 2021. Now, was the Republic of the Philippines still a state party to the ICC at the time that the exercise of jurisdiction was triggered? The Philippines served notice of its withdrawal in March of 2018, and it became effective 1 year later in March of 2019. So at the time that the exercise of jurisdiction was triggered, a precondition for the exercise of that condition jurisdiction was not existent. And what is that precondition? As I said, membership of the Philippines in the ICC. 2 years had already elapsed when the exercise of jurisdiction was triggered. So for that reason, Your Honors, while in fact it is admitted that the ICC had jurisdiction over the offenses committed during that period when we were still a member, quite unfortunately, the trigger for the exercise of that jurisdiction came much too late. And the ICC prosecutor himself should be, well, I wouldn't want to say blamed, but it's his lack of assiduousness that prompted this situation. This is far different from the case of the Republic of Burundi, because in that case of Republic versus Burundi, Burundi also withdrew from the ICC. But before the 1 year period could elapse, the ICC prosecutor commenced his investigation by asking the pretrial chamber for authorization, and the pretrial chamber granted that authorization. So before that 1 year period expired in Burundi, na-trigger yung exercise of jurisdiction. Not so in the case of the Philippines. So, yun po yung legal basis. Baka po tanungin nyo, ano ba yung significance noong 1 year period? Bakit merong 1 year period? The reason for that, Your Honors, is the ICC in the articles, under the articles of the Rome Statute, wanted to balance yun pong two competing interests. One major interest is yung sovereign right of any member state to withdraw from the treaty kung kailan niya gusto. That is one major consideration. Any member, any state, if it doesn't want to continue its membership, it has the sovereign right to withdraw from that membership. What is the other competing interest? The other competing interest is the ICC also wants to make sure that efforts to end impunity are also addressed. So how do you balance these two competing interests? By imposing that 1 year period within which the ICC prosecutor may initiate his investigation before the effectivity of the withdrawal of that state. Yun po yung balancing factor, that 1 year period. But in this case po, ang nangyari, na nag-take effect na po yung ating withdrawal in March of 2019, and yet, nung 2021 lang, more than 2 years later, nung mag-trigger ng exercise of jurisdiction. Kasi hindi naman po pwedeng forever, perpetually, nakatutok sa atin ang ICC kahit na hindi na po tayo miyembro ng ICC. Yun po ang
Ayun.
paliwanag kung bakit there is no legal duty on the part of the Philippine government to cooperate. As I said, it's a political decision. But from a legal standpoint, the President has made it a point, has emphasized that we have no legal duty to cooperate. Now, the other major consideration po is on the issue of admissibility or the principle of complementarity, na which says na ang may primary jurisdiction to investigate all offenses and crimes that happened within Philippine territory belong to the national domestic institutions. At kung hindi po nagfa-function like some rogue states, I wouldn't say in what continent or what, then that's the time that the ICC should enter. Pero hindi naman po tayo nasa category ng isang rogue state.
Ayun.
We have a functioning legal system. We have a functioning judicial system. So while it may not be perfect, what we have been emphasizing is it's there, it's in place, it's working. We all know that. Kung tayo po may problema sa hustisya, we still go to our national institutions, whether we belong to a political party or not. Pag may problema po tayo, we still go to the Department of Justice. We still go to the PNP kung meron po tayong complaint. We still go
Yun.
to the courts kung meron po
Malinaw,
tayong any civil matter that needs to be resolved.
Tama.
So we all know that our domestic system, legal system, is still functioning. So yun po yung punto ng Presidente from a political standpoint. If we allow someone else to do what we ought to do, then in effect we are surrendering part of our sovereignty. So by so doing, are we also parang not upholding the rule of law? Not really. Because if we do so by ourselves, using our own national institutions, that is also upholding the rule of law.
Yun.
For now, that's all that I can say, Mr. Chair, and I'm willing to answer any questions that the members of the committees may ask to clarify.
Ayun.
Thank you, Your Honor.
Malinaw.